Hello and welcome back to SEC Roundup. My name is Nick Morgan. I am the co-founder of ICAN, Investor Choice Advocates Network, and today's co-host. And I am joined, as always, by my co-host and co-founder, Tom Zucchero. Tom, how are you doing this morning?
I'm doing well. Good morning.
We're particularly delighted today to talk about a subject that's near and dear to Tom's and my heart, which is regulated entities fighting back against the SEC, which is an unusual occurrence, but maybe should happen more. And so we're joined by my colleagues at Paul Hastings, our global chair of the Investigations of White Collar Defense Group, Brad Bondi. Brad, thank you for joining.
Hi, thanks.
And our colleague from New York, Sara Ortiz. Sara, thank you for joining.
Hi, thanks for having us.
And not that you two aren't honorable enough, but our guest of honor is Tim Pagliara, chairman and CIO of CapWealth, who went through a fairly remarkable battle with the SEC that we're going to get into a little bit later. Tim, thank you so much for joining us.
Thank you for having me.
So a couple of things have happened recently that are somewhat unusual. I don't know, it may be too early to call it a trend. But regulated entities are fighting back against the SEC. And so this year's Supreme Court term is seeing the George Jarkissi case, an investment advisor who has been fighting with the SEC for more than 10 years. So we're going to see some talk about this topic in the Supreme Court. Listeners of this podcast will know that the group of private fund trade associations recently filed a case in the Fifth Circuit Court of Appeals challenging the SEC's recent rule on private fund disclosure issues. So that was somewhat remarkable. And then in the last couple of weeks, we've seen two sort of household names, rather than settling with the SEC, which is what usually happens, indicating or actually fighting back against the SEC. Virtue has been in the press in the last couple of weeks. And then we don't know for a fact, but it has been reported as early as this morning that Citadel may be fighting on the WhatsApp sweep issues. So these, as I say, is this a trend? I don't know, but it is certainly unusual to see regulated entities like investment advisors and broker-dealers fighting with the SEC in litigation. And Tom, you and I and everyone on this call now has been through litigation against the SEC. What are some of the factors, just generally speaking, that keep regulated entities in particular from litigating?
Yeah, thank you, Nick. And it's a challenge for regulated entities to litigate against the SEC. And hats off to Tim for taking on that fight and succeeding. But when you litigate against the SEC, you have several major disadvantages. First, the SEC starts at second base in almost every trial. They have conducted years-long investigation, one-sided. They've taken all the testimony they want. They've gotten all the documents they want. So they are fully informed of all of the facts when they file their case. The defense is starting not from scratch, but close to scratch. So it's a huge informational deficit for the defense at the start. Secondly, it's really expensive to litigate against this. Tim can address that, but it's often as a business decision cheaper to settle and take it than go through with litigation and pay what will be undoubtedly millions of dollars to take on the government. And the government's an irrational litigant. They'll take a case that they'll spend more than they'll get in remedies because they're all salaried employees. And thirdly, and I think particularly regulated entities, the risks of an adverse decision are extremely high. I mean, not only are you looking at a potential disgorgement and penalties that could be very significant, but for a regulated entity like a registered investment advisor, you can lose your registration and you're out of business. So from a business perspective, again, there's enormous risk in litigating against the SEC. Many of us will remember the market timing cases in the mid 2000s where RIAs were paying 10 million, if not more, to settle these cases which had a unsettled legal basis. But again, the risks of going to trial is so high that most RIAs resolve the cases before that point.
Yeah, no, that's so true, Tom, and maybe more tied to Tim's case, the 12B1 fee issue resulted in loads of settlements for all those factors that you just articulated. Well, let's talk a little bit about Tim's case in particular. Brad, can you give us an overview about sort of what some of the issues were and why this case may have been ripe for trial?
Sure, Nick. And Tom, thank you very much for having us. We're honored to be here, and I'm honored to, with Sara and the team, to have represented Tim Pagliara and CapWealth. Tim's story is an incredible story because he was like many, many registered investment advisors, somebody the SEC came calling about, saying he didn't adequately disclose in his Form ADVs the 12B1 fees that his firm had received. Now, interestingly here, though, what the facts were a bit different here in the fact that what Tim did is he offset his advisor fees by whatever 12B1 fees came in through mutual funds. And many of his clients didn't have mutual funds. If they did have mutual funds, they were coming in from a different platform, a different RIA. And so mutual funds were a very, very small part of Tim's business. So when 12B1 fees would come in, he would offset them at CapWealth, excuse me. He would offset those, his advisor fee, his 1% advisor fee, his standard advisory fee, by whatever 12B1 fees came in the door. And he explained that to clients when they came in. And he would explain, we're doing the offset. But it wasn't spelled out to the SEC's satisfaction in great detail in the Form ADVs. Now, first of all, I don't know too many people who actually read the Form ADVs. I've never read as a client to any RIA a Form ADV, but I listen to what my advisor like Tim would say. And if he says, hey, I charge a 1% fee and I'm going to deduct from that 1% fee the 12B1 fees that you get from the mutual funds, I get it. I listen to that. But the SEC's case was sort of purely built upon this idea that it wasn't sufficient disclosure in his Form ADV. And it was sort of an interesting situation because so many times, I mean, to Tom's point here, so many times we represent clients and registered entities, registered investment advisors, and they realize that the prospect of fighting their primary regulator is not one that's very tolerable to them. So they'll look for a settlement. They'll look for sort of the best resolution here. Tim is a very principled man. And Tim said, I am absolutely not going to settle for something I didn't do. And certainly not something when the SEC was throwing around the F word. And by the F word, I mean fraud. And what's interesting here is, I told Tim at the start of this case, I said, the SEC throws around the F word frequently. Fraud this, fraud that. And all through the allegations, they're accusing Tim of fraud. Tim said, I've never been accused of fraud in my life. And I'm certainly not going to let these guys accuse me of fraud. And I will fight this if I have to. We went through the process. We went through the Wells process. We went through testimony. We produced documents. We had all the meetings up the chain that normally go to this. But the SEC was sort of so set in their ways, and it was very formulaic in the sense of, well, we brought other cases like this. We brought other cases like this. And they cite the precedent. The problem is here, it's not really precedent. These are settlements. They didn't go through a court. There's not legal precedent. You couldn't cite them to a court as saying this is binding authority here. This is what the SEC settled with someone. And oftentimes what they're doing is they're coming in very heavy-handed to registered investment advisors, threatening, all sorts of bad ramifications if they don't settle here. Very much bullying the RIAs. And Tim was not a guy, and I've learned to love and respect Tim, and Tim's my RIA now as a result of having represented him and seeing what kind of man he is and a man of principle. And Tim said, look, I'm not going to be bullied by that. And I'm a man of principle. And whatever it takes, I will fight back. And I will defend my reputation, that of my colleagues, and that of my firm. And that's what he did.
Yeah, and it was an incredible story, and we sort of buried the lead here, but the jury in that case returned a verdict in Tim's favor late last year. And so your principle paid off, Tim. Brad, we sort of we jumped right into the litigation phase of fighting back against the SEC. But we sort of skipped over something that both you and Tom alluded to, which is there's this whole process before they even file a complaint that occurs. Sara, what was sort of remarkable about the pre-litigation events in this matter that you worked on?
Hey, Nick. Yeah, so there were two. So the first was, the latter part of this investigation, or, leading up to the Wells process, occurred during COVID. So, the first was, this was just a very challenging time for everyone, but, CapWealth, business-wise. The SEC was interviewing, folks, including, CapWealth clients, over the phone as opposed to in person. But the second was, as Brad alluded to, the SEC it was clear they were very set in their views on this case from very early on. And, typically the SEC does not issue a Wells notice until they've completed their investigation. In this case, they had asked us to sign a tolling agreement and we refused. And so as a result of that, they actually issued a Wells notice before they completed their investigation, while they were still in the process of collecting documents and interviewing witnesses.
Yeah, that is remarkable, and it just adds to the cost, right? It adds to the incentive to settle if you've already gone through this process. So they did file a case, Tim, and so now you're faced with a complaint by the SEC. I think 98%, I think, is the statistic I've heard. 98% of cases that are filed by the SEC get settled. I bet if you broke that down and limited it to IAs and BDs, the number would be even higher. And yet you didn't settle. So for our audience, can you maybe talk about some of the factors that led you to take the remarkable decision to stick with it and fight all the way through trial?
Well, thanks for hosting this. I guess the first most fundamental thing is we didn't do anything wrong. We did what the SEC asked us to do with disclosures in 2011 when they did our first audit. And we didn't change those disclosures up until the time that we shut down our broker dealer. And then we amended the ADV because we didn't have a broker dealer. We were no longer collect 12B1 fees. And the SEC fought to keep that audit, the results of that audit, out of the trial. And, it came down to the difference between the word may and shall. So they had 8 lawyers, 2 experts, a jury consultant, and they ran us right into federal court and we ate their lunch. We discredited their experts. Their in-house expert was almost held in contempt of court for violation of the exclusionary rule. And he started changing his testimony the day after, the trial, had concluded for the day. They had their other expert broke down on the stand after he was caught in a series of contradictions in this video deposition and his testimony. They had a client, the only client that they could get to testify hadn't been a client since 2015 after her mother died. They brought her all the way from Lilburn, Georgia. She's 80 years old. They set up her deposition for an hour, or her testimony for an hour. And at the end of it, my attorney stood up and he said, ma'am, do you even know why you're here? And she said, no. Would it surprise you to know that the SEC has brought you all the way up from Lilburn, Georgia, paid all your expenses, and the amount in question, $76? And she said, yes. And he said, no further questions. She got up off the stand, walked by me, gave me a hug in front of the jury, and left the room.
Yeah.
And that's the part of this that's just maddening, because they were threatening to ban me from the industry for life over something they hadn't even investigated. And, I got the kind of personality. All that did was harden me. We went through 4 court-ordered mediations. These neither admit nor deny settlements are really an admission of guilt, when you examine them and the constraints that are put on you. So I just wasn't having it. And it cost us in direct legal fees, $1.8 million. I've got 2 CPAs and 3 CFAs on staff. So we were our own in-house expert to rebut all that. So that would have been easily $1 million. And I estimate the SEC spent well over $4 million in bringing this case. So it was a waste of taxpayer money. And at the heart of it, it was not in the best interest of my clients, because at the end of the day, they could not rebut the fact that the tax deductibility, among the other issues that we mentioned, like Brad said, the tax deductibility of 12B1 fees make it very efficient for clients. And after 2018, with that tax bill, advisory fees are not deductible. But inside a mutual fund, it's an ordinary and necessary business expense, so it is deductible. So clients were getting on whatever 12B1 fees they were paying, they're getting a 40% discount if they're in a 40% tax rate,
Right.
from the IRS. They had no answer for any of that. And they were just on this track where you're guilty. And it's a terrible thing, and it's, I hope to get legislation passed, and I'm working hard on it, that would require the SEC to reimburse the prevailing party in these cases, to make them somehow accountable financially for what they do and how they disrupt businesses like mine during a very stressful period of time.
Very stressful with COVID and going through this at the same time. It's a remarkable story. In fact, if you had settled, Tim, we would not be able to have this conversation. You would be precluded from doing that. So, but thankfully, the jury came back in your favor, and we can talk about it. So, as the investment advisors face potential actions relating to this WhatsApp ephemeral messaging sweep, if that's what's going to happen, they can look at you as an example. It sounds like facing the consequences that the SEC routinely puts against RIAs and BDs and the expense. It takes fortitude and principle in addition to the ability to pay lawyers to get through the process. But you are evidence that you can get through the process. So glad to hear about your story. Really, thank you for joining us today on SEC Roundup. Brad, Sara, Tom, thank you all for joining. And we'll see everybody else on the next episode of SEC Roundup. Thank you.
Thank you.
Thank you, everyone.
Thank you.